Hello, this is a small video for the Accounting Technicians Ireland Work-Based Learning Log. So this is in relation to law and business, and in particular employment law. So employment essentials. So the national minimum wage is an employer essential. They are obligated to pay of their employees at least the national minimum wage. So for everyone who is 21 and under, the rates on the right hand side here are as follows. So we see the current rate as set in October 2016, and underneath them we'll see the new rates for April 2017. Anyone who is 25 and over are entitled to the national living wage, which is currently set at £7.20 and due to rise in April 2017 to £7.50. Moving on, so these are other employment essentials that employers are obligated to give their employees. So every employee is entitled to holiday entitlement. You'll see to the right hand side here just the actual legislation as set out by HMRC. So for all workers, most of them are legally entitled to 5.6 weeks paid holiday per year. So just to give a snapshot of this, on a contracted basis, if somebody is contracted to work 5 days a week, we would usually multiply this by 5.6 weeks to give their annual entitlement, and that would give them the 28 days. That's the statutory minimum that employers are to give their employees. Now, employers can make their employees take out bank holidays out of this entitlement. And then again, if we have anybody who's maybe contracted to part-time hours, maybe 3 days a week, then this is then apportioned, and then so you'll see below there the 3 days at 5.6 weeks per year. Employees who have casual contracts aren't required to work specific days, but they may have an hourly contract, so they may be obligated to fulfill 5 hours per week, for example. So for each hour worked by an employee, their entitlement then is 0.1207 hours. Holiday entitlement, so usually this is just accumulated over the year, and this would be paid to an employee by an employer, maybe in a specific period, perhaps the end of year. So moving on to employee and employer obligations. So there are a few obligations that both the employee and employer have to fulfill to each other. So one of these obligations are pay slips. So employers are obligated to provide employees with a pay slip per pay period, P45s and P46s. So an employer is obligated to provide a leaver with a P45. If this P45 is not available when it is needed by the new employer, a new employee then must fill out a P46. So obviously there will be tax implications with that, but that will be discussed in a different video. P60s, employers are obliged to give their employees a P60, and this will basically detail the gross payments and deductions for the payroll during the year, ending the 5th of April of each year. An employer must also provide their employee with a P60 by the 31st of May. Just to highlight some notice periods, so we have statutory and contractual notice periods. So contractual notice periods will be the notice periods that are actually specified within the contract between the employee and the employer. However, there are statutory minimum requirements that employers and employees must also give one another. So an employee who has worked 1 week to 2 years must give their employer 1 week notice, and likewise if an employer is going to make an employee redundant or terminate the contract for any reason, then the 1 week notice must also be provided to the employee. 2 years to 12 years is 1 week notice period per year employed, and you'll just see there just underneath it's 12 years or more, and if you are employed 12 years or more, then it is 12 weeks notice. So a particular area I'm going to focus on here is with the legislation. So I know this is part of the Accounting Technician Work-Based Learning Log requirements. So I'm going to focus on the example of maternity leave, maternity pay, and the maternity entitlement. So these are just the key points, just highlighting entitlements that employees have and obligations that employers must fulfill. So with regards to leave, an employee is entitled to maternity leave, which is in its full 52 weeks. So 26 weeks of this leave is called ordinary leave, and 26 weeks is then called additional leave. A pregnant employee must take at least 2 weeks minimum after the baby is born. So this is just basically with health and safety obligations just to the employee and the employer. And we must specify that whenever a woman is actually on maternity leave, there is a degree of security surrounding the woman's job within this time period. So in order to qualify then just for the maternity leave, a woman must prove the pregnancy. So this is done by submitting a MAP B1 form, which must be signed by a doctor or a midwife. An employer must be notified of the pregnancy 15 weeks before the expected delivery date, and they also must be notified when you intend to start your maternity leave. The earliest start of leave is 11 weeks before the expected due date. And if you wish to change the maternity leave start date, this must be provided to your employer in writing, and it must be 8 weeks before the intended change. So moving on to pay then. So statutory maternity pay is paid up to 39 weeks. The first 6 weeks is paid at the rate of 90% of the normal earnings that the employee would usually have. The remaining 33 weeks is paid at 139.58, which is the current rate, or 90% of the normal earnings that the employee would usually receive. So it's the lower of each of those. Again, this is a taxable benefit which is subject to PAYE and NIC. In order to qualify, an employee must earn more than £112 per week, and this is due to the lower earnings levels. We'll just talk about this in the next slide. If you're not entitled to this, and you perhaps earn less than this per week, you may be entitled to maternity allowance, which is available through the Job and Benefits Office. An employer, if they cannot provide you with SMP, they must provide you with an SMP1 form to enable your claim then for maternity allowance. Moving on. So the role of national insurance contributions. So employees are eligible for SMP if they earn £112 per week gross or more. So at the minute, £112 per week is the lower earnings level. If employees earn below the lower earnings level, they do not pay NICs, so they therefore do not have any protection for state benefits. So they may not be entitled to things such as SMP, SSP, or contribution-based job seekers allowance. However, if an employee earns at the lower earnings level to the primary earning level, they still don't pay NICs, but they are afforded the protections of those state benefits mentioned above. And then again, if an employee then earns above they earn at the primary earning level or above, employees pay national insurance contributions at class 1. That is currently set at 12% for the employee and 13.8% for the employer. So for further reading, I would always go to HMRC. They clarify everything that I need to know, and it's best to get the information straight from the government themselves. Thank you for listening to this video.